I call the meeting to order. As chair of this forum, it is my pleasure to introduce the plenary panel, which will discuss the importance of regional action for the global implementation of the United Nations Guiding Principles. We are very lucky to have with us for this session a representative from the Council of Europe, the African Commission on Human Rights and People Rights, and the ASEAN Intergovernmental Commission on Human Rights and Inter-American Commission on Human Rights. Although business and human rights are of global concern, the core of the business and human rights agenda involves ensuring that rights are protected and respected on the ground. Most business and human rights concerns, as well as solutions, arise at the local, national, or regional level and are most effectively addressed there. Promoting wider implementation of the guiding principles and deepening the involvement of all regions are key strategic objectives for the business and human rights agenda. Regional organizations may play an important role in reinforcing business and human rights standards and ensuring convergence between various implementation efforts. This session will take a sweeping look at strategic consideration for moving toward full global implementation of the United Nations Guiding Principles and explore how the involvement of each region may be strengthened. I would now like to invite Working Group Chair, Madam Alexandra Guáqueta, to open the dialogue. You have the floor, ma'am.
Gracias, Presidente.
Thank you very much.
Les relataré 4 puntos cortos.
I will make 4 brief points by way of conclusion of the session that we had yesterday on the regional dialogues. Yesterday, in parallel, there was a regional session on Asia, one on Latin America, one on Western Europe, Australia, New Zealand, Africa. In many places, the regional institutions are still a resource which is not used sufficiently in the implementation of the guiding principles. In particular, I would like to mention how important it is for the financial institutions, the regional ones, that they should align their safeguards on the guiding principles, and that the capital that they loan should and invested in markets should flow only after due diligence exercises, which target, as we heard in the earlier session by the representative of civil society, on risks and impacts on persons. The regional human rights courts can do more to refine their sentences as far as what the states and enterprises can do in order to respect and also to compensate. Also, the political bodies can do more to encourage states to formulate and implement national plans of action and tackle the urgent matters on the ground. They can also assist in promoting regional consensus and coordination, especially in places where there are dynamic emerging markets. Foreign direct investment, FDI, from the emerging markets to their own regions continues to grow with respect to the global investment figures. Many places, this is my second point now, that was my first point, have challenges with respect to the implementation of the law and the fulfillment of the existing agreements in human rights and fulfilling their own laws that exist already. Efforts to strengthen institutional capacities as far as the implementation of laws in the area of property, use of land, environmental, labor are all extremely important, and the guiding principles assist to focus these efforts in order to understand by way of priority the effects on the victims and people who are affected by the various economic projects that seek to meet the needs that we all have namely that there should be infrastructure, energy, food, and so on. Number 3, as one moves forward, there is an opportunity to make progress with the entrepreneurial associations and civil society in order to strengthen and to support social harmony. This should not be a platform that it goes in the direction of polarizing and which divides society on a daily basis. Instead, this platform, the guiding principles, must assist to have a joint dialogue. Number 4, there was a lot of emphasis laid on the fact that discussions in Geneva and the commitment which the states talk about in Geneva, that this should actually materialize in a more, shall we say, concrete way at the local and at the national level. Thank you very much, Chairman.
Thanks, Madam, for your important statement. Now, I would like to invite distinguished Mr. Philippe Boillat from the Council of Europe. You have the floor, sir.
Monsieur le Président,
Mr. Chairman, Excellencies, ladies and gentlemen, allow me to begin by expressing my heartfelt thanks to the organizers of this forum for having invited me to speak here on behalf of the Council of Europe. This forum is an excellent opportunity to strengthen both dialogue and synergy among all role players, both universally and regionally, who are involved in the relationship between human rights and the role and responsibility of enterprises. We all must see to the consistency of our action in order to achieve the goal which we are all heading towards, which is the full implementation at the global level at the world level of the guiding principles of the United Nations. The Council of Europe is a regional organization which is specialized in the promotion and the protection of human rights. Its work in the area of human rights and enterprises fit extremely well and are completely in line with the approach for the implementation of the guiding principles of the United Nations at the regional level. I'm going to introduce to you now the results that we expect to see over the course of the next 2 years, after following on the adoption in 2010 by the Parliamentary Assembly of the Council of Europe of a resolution and a recommendation, the title of which is Human Rights and Enterprises. The Council of Ministers of the Council of Europe has undertaken a study on the feasibility and the value added of possible standard-setting work of the Council of Europe in this area. The study was prepared in 2012 by our Guiding Committee for Human Rights, the CDDH, and it recognizes the central place of the guiding principles of the United Nations for the implementation of the framework in order to protect, respect, and repair. The study recognizes the value of these principles as norms which have world-level authority to prevent and act on risks of negative effects on human rights associated with the activities of enterprises. This study explores, finally, the interest and the possibilities for the Council of Europe on the basis of its expertise to carry out this sort of work by doing the following: supporting the implementation of the guiding principles at the level of Europe, providing supplementary action as a regional organization without overlapping or reproducing the principles, by strengthening also awareness of the guiding principles at the regional level, and by going into more depth in those issues which are mentioned in the guiding principles, for which the action of the Council of Europe, because of its expertise, could bring about a real value added. On this basis, on the 30th of January 2013, the Committee of Ministers gave a mandate to the CDDH to do the following by the end of 2015. First of all, to develop a declaration of the Council of Ministers supporting the guiding principles of the United Nations, and secondly, in cooperation, close cooperation with the private sector and civil society, that it should develop or produce a non-binding legal instrument which could include a guide of good practice and which responds to the gaps identified at the level of Europe in the implementation of guiding principles, including access to justice for victims of violations of human rights by enterprises. A drafting group has been set up thus to prepare this work. Here we're talking about an intergovernmental committee, the members of which are experts appointed by governments of our 47 member states. We remain, however, convinced that the success of this work will have to involve associating as closely possible and from the very beginning other international organizations, as well as civil society representatives and enterprises which are active in this field. Thus, the Office of the High Commissioner for Human Rights of the United Nations, the European Union, the OECD, a number of different social partners and specialized enterprise networks in this area of social responsibility have been invited to participate to the meetings. The chairman, Mr. René Lefebvre, and the secretary of this working group of the Council of Europe participate also in this forum, are participating in this forum. At its first meeting, the working group was able to put the finishing touches on the draft declaration of the Council of Ministers. This is a political support document supporting the full implementation of the guiding principles of the United Nations. This draft was approved by the CDDH last week and will very probably be adopted by the Council of Ministers in February 2014. As to the much more ambitious development of a non-binding legal instrument, the working group has identified an indicative list of possible subjects to be discussed with a view to including them in the instrument. This instrument should focus on the implementation of the guiding principles which address first and foremost states, and more specifically those areas in which the Council of Europe has specific expertise. Thus, we have obligations which flow from the legal instruments of the Council of Europe and obstacles standing in the way of access to justice or appeals, possibilities for victims. The list also includes sensitive areas such as extraterritorial competence, and the working group will be looking very closely at each of these issues in order to try to pinpoint possible gaps. Normative gaps in terms of the awareness or implementation, and the group will possibly come up with measures to remedy these measures, which will be based as far as possible and as much as possible on the good practices which already can be drawn from the member states. I am convinced, Mr. Chairman, that this forum will allow us to share even more our experience with the experience of other regional organizations and the United Nations. This is a source of inspiration which is absolutely essential for our work. As far as I'm concerned, I can only encourage every regional organizations to proceed to an analysis of the norms and existing gaps in their own context and their own ability to be able to contribute value added to the guiding principles of the United Nations. It's important to take ownership of these principles and to make them the basis on which it will be possible to build an effective system for the promotion and protection of human rights, shared with all partners and more specifically with enterprises. Thank you very much for your attention.
I thank you for your important statement. May I now invite distinguished Mr. Kaggwa from African Commission of Human and People's Rights. You have the floor, sir.
Honorable Chairman, Excellencies, distinguished working group members, ladies and gentlemen, very good morning. It is a great honor for me to attend the second annual forum on business and human rights and to give this presentation on behalf of the Chairperson of the African Commission on Human and People's Rights, Commissioner Kaites Zainabu. As a word of introduction, you all know that governments have the primary responsibility to promote and protect human rights. However, increasingly there have been a rise in non-state actors which have the potential to positively or negatively affect the enjoyment of human rights. These non-state actors, such as transitional corporations and other businesses, are increasingly playing an important role, both internationally and at the regional level. This growing trend of influence, which impacts directly on lives of ordinary citizens, has initiated discussions on the roles and responsibilities of such actors with regard to human rights. We, however, appreciate that many business enterprises greatly contribute to the enjoyment of human rights, for example, through creation of employment, through provision of social amenities, etc. Unfortunately, it is increasing the reality that some of these business enterprises directly or indirectly violate human rights. All over the world, serious allegations have been made and unfortunately continue to be made about business involvement and responsibility in human rights violations and environmental damage. States, as primary guarantors of human rights, have either inadequately addressed these violations or have failed to provide redress. The result is that victims of human rights violations or serious environmental damage directly linked to the economic activities of multinational corporations often struggle to obtain just as such. Impunity often prevails. Mr. Chairman, at the international level, a set of guiding principles on business and human rights developed by the former Special Rapporteur provide an authoritative standard for preventing and addressing the risk of negative human rights impacts linked to business activity. With that background in mind, permit me to turn to the regional human rights system. At this point, it is useful to note that the African Commission on Human and People's Rights, hereinafter called the African Commission, does not have the mandate to implement the UN guidelines principles, nor does it address the topic of business and human rights per se. Rather, in this presentation, I hope to highlight the efforts which have been made by the African Commission with regards to the promotion and protection of human rights in relation to non-state actors such as business or multinational corporations. The African Human Rights Commission is centered in the African Charter on Human and People's Rights, which lays out a range of rights and duties that should always be respected. The Charter proclaims not only rights, but also duties, and it guarantees both individual and people's rights. In addition to civil and political rights, the African Charter sets out a series of economic and social rights, thus making them equally justiciable. In ensuring its protection mandate, it's important to note that the work of the Commission is complemented by the African Court on Human and People's Rights, established under the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights. In addition to performing tasks entrusted to it by the Assembly of Heads of State and Government, the Commission is officially charged with the three functions: promotion of human and people's rights, protection of human rights, and interpretation of the Charter. This it does through communication procedure, which has become an essential component of the African human rights system. And the African Commission is increasingly dependent on this procedure in exercising its protective mandate. It has developed jurisprudence that has mainly shaped the way to rights and duties enshrined in the Charter. Mr. Chairman, I'll now turn to the work of the African Commission in relation to business and human rights. As earlier noted, the African Commission has not engaged in the promotion and protection of human rights, and especially in relation to the topic of business and human rights. However, the African Commission has over time taken cognizance of the human rights violations perpetrated specifically in the extractive industry sector. Primarily through its protection mandate, the Commission received persistent reports of human rights violations committed by non-state actors in relation to the extractive industry, including by various groups such as rebel groups and private companies working in different economic areas in many African countries. The complaints detailed human rights violations in relation to Article 21 and 24 of the African Charter, which respectively guarantee the right to all persons to freely dispose of their wealth and natural resources and to a general satisfactory environment favorable to their deployment. For example, in the so-called Ogon case, the Commission held that government have a duty to protect their citizens, not only through appropriate legislation and effective enforcement, but also by protecting them from damaging acts that may be perpetrated by private parties. Furthermore, in addition to complaints received, the African Commission received several reports from NGOs with observer status regarding human rights violations by various groups and private companies working in extractive sector in the African countries. These reports raise several issues ranging from warlords' activities, the environment, and the mining industry. In response, the African Commission was faced with the challenge of making the nexus between violations of human rights and people's rights by non-state actors and ensuring that perpetrators of human rights violations were held responsible. As a result, the African Commission, at its 39th ordinary session, decided to undertake a study on human rights violations committed by non-state actors. The report subsequently adopted by the Commission proposed the establishment of a special mechanism to further examine and propose a way forward to address this thematic issue. Thus, in recognition of the pervasive human rights violations allegedly committed by non-state actors and the resulting destruction of the environment as a result of extractive activities, the African Commission established a new special mechanism that is the Working Group on Extractive Industries, Environment and Human Rights Violations in Africa in 2009. The mandate of this working group includes, inter alia, examination of the impact of extractive industries in Africa, the possible liability of non-state actors for violations of human and people's rights, in addition to the task of developing recommendations and proposals on prevention and redress for victims of violations. It is the expectation of the African Commission that this working group will contribute to the development of jurisprudence as a base for holding non-state actors responsible for violations of the rights enshrined in the African Charter. In fulfillment of its mandate, the Working Group on Extractive Industries is currently undertaking academic research, conducting research and information missions to state parties, convening meetings with various stakeholders in order to gather information and investigate human rights abuses committed as a result of the extractive industry in Africa. It is my belief that the report presented by the Working Group on the African Commission at the end of its mandate will provide guidance on how to address allegations of human rights violations committed by extractive industries in Africa and will propose a way forward to ensure redress and access to justice for victims of human rights violations in Africa committed by non-state actors. Through its work, the Working Group on Extractive Industries has sought to collaborate with various stakeholders, including non-government organizations, national human rights institutions, state parties to the African Charter, and even the Working Group on the issue of human rights and transitional cooperation and other business enterprises, which is hosting this forum. At the recently concluded 54th Ordinary Session of the African Commission held from 22nd to 5th November, these two special mechanisms jointly hosted a panel discussion on illicit flight of capital and the extractive industry in Africa. It is through such collaboration that the Working Group on Extractive Industries will successfully achieve its mandate and advise the African Commission on how to address the issue of human rights abuses committed by non-state actors. I thank you.
Thanks for your important statement. May I now invite Mr. Rafendi Djamin from ASEAN Intergovernmental Commission on Human Rights. You have the floor.
Members of UN working groups on business and human rights. It is an honor for me to represent the new commission in the world, the ASEAN Intergovernmental Commission of Human Rights, a commission of 10 member states in Southeast Asia. It was established in 2009 as a consultative body of associations of Southeast Asian nations on matters pertaining to human rights. The existence of ICHR now illustrates the strong commitment that ASEAN is willing to pursue in promoting and protecting human rights in our region. Human rights, after all, is an integral part of ASEAN community building. Article 1.7 and 14 of the ASEAN Charter, for example, emphasize the importance of ASEAN's gift to human rights. Since its establishment in 2009, ICHR has conducted many activities to materialize ASEAN commitment to promote and protect human rights. The priority areas of ICHR is well reflected in our 5-year work plan 2010-2015. As part of its work plan, ICHR has identified several current and potential human rights issues that are of interest of ASEAN, which, among others, include matters pertaining to the nexus between business and human rights in our region. The selection of business and human rights as one of the key thematic human rights issues of ICHR was in line with the global effort under the leadership at that time of Professor John Ruggie to develop a guiding framework to regulate corporate behaviors, both at the national and international levels. Among other things, economic development, after all, has been a key aspiration of ASEAN member states. Filling the development gap among 10 ASEAN member states has become the one of the main purpose of ASEAN economic cooperation. Indeed, economic activities have not only been fervent within the region, but has also been prevalent in our engagement with the global community. Given the strategic economic significance that ASEAN possesses today, IHR believes that greater attention must be given to human rights implications of corporate conducts in the region. Accordingly, in early 2012, IHR set up a team to carry out baseline study on this very issue. At its first coordination meeting, which took place in Singapore in the same year, the study team members and the national focal points for the above-mentioned assessment agreed that corporate social responsibility, or CSR, was to be chosen as the framework for the Commission studies on the business of human rights, which is increasingly recognized as a relevant tool to advance corporate governance, accountability, and transparency. CSR is also gaining popularity across the private sector in the region. ASEAN CSR Network was established back in 2010 with its members in its 6 ASEAN countries. Besides this action line, at the level of ASEAN Ministerial Meeting on Mineral, which is part of the economic pillar, it has also embraced the voluntary principle of extractive industry transparency initiative. It has included in the action plan for 2011-2015. Although CSR has a direct connections regarding business practices, it is not included in the agenda of ASEAN Economic Community Blueprint. Instead, it is included in the ASEAN Sociocultural Community Blueprint. The ASEAN Sociocultural Blueprint section on social justice and rights call for CSR principle to be incorporated into the corporate agenda of businesses in the region and contribute towards sustainable economic development in ASEAN member states. Now, with the establishment of ICHR, the ASEAN Intergovernmental Commission on Human Rights, as an overarching organ across the 3 pillars of ASEAN cooperations, and the adoption of ASEAN Human Rights Declaration in November 2012 by head of states of ASEAN, the international norms and standards of human rights revered in the UNGP on business on human rights should be integrated in the ideas in the ASSC blueprint through its action line. It is our expectation that the study team on business and human rights will be able to formulate initial recommendation for the development of a common framework in the acceleration of the promotion of CSR and human rights in the region. Chair, ladies and gentlemen, UNGP on business and human rights, which was unanimously endorsed by the UN Human Rights Council in 2011, has been an integral part of our effort to understand better linkages between corporate conducts and human rights in Southeast Asia. As I mentioned earlier, our region is currently undergoing a period of rapid economic development as ASEAN continues to improve its competitive strength in the business arena and it integrates itself in the global economy. There is a necessity that our region is able to maintain appropriate standards in corporate governance, accountability, and transparency. While striving for sustained economic growth, corporate abuses unfortunately remain rampant throughout the ASEAN region. As in case with many emerging regions, conflict in the rights to land, environmental degradation, as well as migrant labor abuses and human trafficking are some of the key issues commonly associated with many business practices in our region today. All this evidence suggests the importance of better managed business conduct and the stronger role of the ASEAN member state in providing legal and regulatory framework on business conducts. Also provide various incentives, and last but not least, the enforcement of those regulatory framework. While it's generally accepted as global norm to regulate corporate conducts at the international level, in the implementation of the UN guiding principle on business and human rights remain both challenged in and uneven throughout ASEAN. For example, while international pressures and to a certain extent the push for domestic economic reforms have encouraged some ASEAN member states to give greater attention to the UN Protect, Respect, and Remedy framework. Other member states have yet made any specific reference to these principles in many of their domestic policies. Overall, the prospect for the implementation of the UN Guiding Principle in ASEAN region is not all bleak. As a way to attract foreign direct investment, for example, civilian government of Republic of Union Myanmar has given its commitment to observe responsible investment practices in the country. In addition, some of the country-level analysis carried out under ICHR thematic study on CSR and human rights have also indicated the existence of numerous domestic regulatory framework that attempt to address the issue of irresponsible business practices. Despite various efforts done at the regional and national level I mentioned earlier, the implementation of UN Guiding Principle remains a challenge for ASEAN and its member states. The level of awareness on the existence of the UN Guiding Principles among state and non-state actors remain limited. Thus far, much of the attention given in the analysis of business and human rights in the region have also been focused on large and multinational corporations, whilst little outreach have been done on the issue to key backbone of ASEAN economies, which are the small and medium-sized enterprises. The collective irresponsible business conduct of these economic actors are equally damaging to similar conducts carried out by their larger counterparts. Moreover, in order to create a critical mass on the support towards implementation of the UN Guiding Principle in the region, the demonstration of real impact of irresponsible corporate conducts must be intensified. Studies on the subjects must be encouraged, while the dissemination of information on the issue, especially through the media, should be improved. Another key challenge that ASEAN and its member states must address is mainstreaming of business and human rights agenda in their political, economic, and socio-cultural policy. While this would require major institutional reforms of ASEAN and its modus operandi, recent development to address the issue in the region is a positive step towards that direction. There is little doubt that much needs to be done in ASEAN region to promote implementation of UNGP. It will require the role of ASEAN and its member states to fully commit the protection of human rights, active participation of private sector to respect human rights, as well as other non-state actors such as civil society organizations, the media, to continuously monitor the promotion and implementation of this principle. Thank you, Mr. Chair.
Thanks, Mr. Rafendi Djamin, for your statement. Now I invite Madam María Claudia Pulido from Inter-American Commission on Human Rights. You have the floor, ma'am.
The Inter-American Human Rights Commission is an intergovernmental body which was set up at the OAS. It's an autonomous, independent body which is entrusted with seeing to the promotion and protection of human rights of the 35 member states which make up the Organization of American States. The instruments which regulate the Inter-American Human Rights Commission are, the main ones are the Declaration on the Rights and Duties, which goes back to 1948, and the American Convention on Human Rights, which when it came into force in 78, and which applies to 25 states of the region. These instruments, which are dynamic in nature, mark the path which has been followed by the Inter-American Human Rights Commission, but does not limit it to that, because the Commission establishes an interpretation clause in Article 29B, which broadens the framework, the scope rather, to all of those norms which are universal in nature or regional, and also to principles and guides that can be applicable and which are more protective than the inter-American law itself. Turning now to the normative framework, it is, I think, very important to mention Article 36 of the Charter of the organization, which provides for transnational enterprises and foreign direct investment, private investment are submitted to the jurisdiction of competent national courts of recipient countries and to the international treaties and conventions in which, to which they are party, in addition to which they must fit with the laws of the recipient countries. These inter-American clauses have been developed through the Commission, through its various mechanisms. In particular, since the 90s, the Commission has received some information and a number of requests and petitions about damage to the environment and the effects of this damage with respect to individuals, but also with respect to the integrity of the indigenous peoples living in the region. Central issues such as the right to life, personal integrity, health have all been developed through the case law of the Inter-American Human Rights Commission and the Inter-American Human Rights Court. Because there are no specific instruments in this area, the case law has been the one which developed Inter-American standards, which do not lead to discouraging development or preventing it, but they do require that development should take place in conditions such as those where the human rights of individuals and peoples are fully respected. In terms of standards, the Inter-American Human Rights Commission's test refers to the conditions within which these major types of development or extractive projects for natural resources can be developed. The test that is applied, in fact, has three basic elements. When this type of development is going to be carried out, extractive industries, for example, that the people must have access to information. We're talking about information that has to be faithful information and complete information. Secondly, that the individuals must participate in the decision-making processes. But in order to participate effectively, what is required is that they have, as was said earlier, that they have to have access to all of the information based on the good faith principle. And thirdly, what is absolutely fundamental and has been developed in those cases is that the judicial resources must be available. It has to be guaranteed to the access of effective judicial support, which is mentioned in Article 25 of the Convention. This test has been implemented by the Commission, both in terms of the final concluding observations in countries where it has looked into the problem very specifically. I'll give you an example. There was a visit which was carried out to Ecuador in 1997. And in the country report, the Commission tackled directly the topic of the responsibility of the state for the consequences on the environment, in other words, impact environment, for the extraction of oil and the joint responsibility that it had with the enterprises in terms of how essential it was to guarantee the elements which were mentioned there and which lead to the protection and guarantee in cases where, and to ensure that the extraction of such resources respects the environment and the health and integrity. The interesting point is that these elements, which we are talking about back in 1997, were applied to specific cases through the case law of the Inter-American system, such as, for example, in the cases which were raised at the Inter-American Court of Human Rights, Aramaka, Ayaku, those cases where we also have a development by the Inter-American Court of the principles which are associated with prior consultation, prior consent, in order to guarantee both the territory, not only the ancestral territory, but also the natural resources. And finally, in the year after 2000, there were precautionary measures which refer to the fundamental rights of hundreds of thousands of individuals who have been affected by this type of development. However, up until now, since the case law of the Inter-American Commission has focused on relations of the state with the individuals that are subject to the protection of the state, it refers to the responsibility which the state has, which is incumbent on the state, which is a member of the OAS, on the activities of enterprises carrying out activities within their territory, and which, as I said, refers to persons who are under their jurisdiction. However, this relationship has involved a challenge recently, and this is based on what the civil society organizations have brought up at the Commission in the last session, which just finished on the 8th of November last. In that space, a hearing took place about the responsibility of states with respect to the enterprises which are involved in the exploitation of mineral resources. And there, the civil society organizations challenged the Commission, where they asked what is the responsibility for violations of human rights of those enterprises when those violations take place in the territories of other member states. And this question has not actually been developed by the Inter-American Commission of Human Rights Commission. It's a question that actually presents a challenge on the extraterritoriality of the norms that are applicable in the area of human rights of enterprises. And this challenge not only goes beyond the borders of the Americas, and it at the focal point of a universal discussion in the global discussion. It's a challenge that we consider could be further developed in this forum in order to bring input into the discussion within the Inter-American Human Rights Commission. Thank you for your attention.
Thank you, Madam, for your important statement. Now it's come to the opportunity of the participants to make intervention. Before I give the floor to speak, I would like to inform you some arrangement. There are 3 tables designated for each of the following groups. 1, state, national human rights institution, UN entity, intergovernmental and regional organization. This is that group, on the left side. Second is business enterprises, professional association, and networks, law firm, and consultant. It is just in front of me, This is the first row of the table. The third one is a civil society organization, trade union representative, indigenous people organization, affected stakeholders, academics, multi-stakeholder initiative, and others. It is on the right hand of me, on the first floor. If you wish to speak, please move down from your seat at any time during the panels to the table which correspond to your group. The chair will then give the floor to one speaker from each of the tables in turns on a rotation basis. Once you have given your remark, please leave the speaker's table and return to your original seat so that the seat at the speaker table become free for someone else to move down from their seat. Those interesting to speak from the floor will have 2 minutes only. Now I open the floor to speak. First, I would like to ask from the state, for number 1.
Merci beaucoup, Monsieur le Président.
Thank you very much. My name is Marie de Carnet, French ambassador for the social responsibility of enterprises, and I would like to begin by saying that France is extremely pleased with the involvement of human rights in business. My function, this is an innovative approach because it is something where I think we have to be very creative and innovative, and my post was created 5 years ago. I have just started working here, and I'd be very happy to know whether other countries have this type of post. It is also in the spirit that France is currently developing its national action plan for the implementation of the guiding principles of the United Nations, and it is doing so while approaching the National Human Rights Commission, which has just given its opinion and which presents a range of recommendations, which will be a very broad range, which will be looked at during the platform for social responsibility of enterprises, which was set up this last summer by the government, and which brings together all stakeholders and in society. We're talking about the state, enterprises, labor unions, NGOs, associations, and so on. And this will, I think, lead to a very inclusive, very global approach, a very large, broad dialogue, a little bit like this forum here, in order to have a cross-cutting approach, which will allow us to go beyond the individual sectors and approaches. And this, I think, shows the commitment of my country. We were the first ones to introduce in 2001 an obligation that was strengthened afterwards in terms of human rights, because this topic has been further reinforced after the adoption in 2011 by the United Nations of the guiding principles, and the government also has an obligation to report to the Parliament, the French Parliament, and we also have a plan of action which was the subject of a peer review, and this is a new approach. I will conclude now. Thank you.
Thanks, Madam. I would like to give the floor to the representative of business. Yes, sir, you have the floor.
Sorry, thank you very much. My name is Adam Green. I'm with the U.S. Council for International Business, which is the U.S. affiliate to the International Organization of Employers and the International Chamber of Commerce. I really just wanted to augment the summary of the business session that was provided earlier today to emphasize one additional point. That was really the focus of our discussion on the state duty to protect. And it's a critical element for business, really to flag the key point in the guiding principles. They made a clear difference between the role of states and the role of enterprises, and that has to be kept in front of everyone's minds going forward. There are things that governments can do and should do that companies simply cannot do. We don't have the political mandate, we don't have the responsibility or the mechanisms to enforce the law. And that's a critical piece going forward. The starting point is that every country has laws. Most of them are very good. But a challenge in many countries is that those laws are not implemented and enforced consistently. And there's a very big gap in some areas between what the law says and what is actually done in practice. And the only entity that can really resolve that problem is the government, the national government at the national level. And in the long term, the solution has to come from within the country. Nobody from outside the country, not other states and not business from outside the country, can fix national systems. And so it's that bottom-up, national level improvement of effective implementation and enforcement of law that is a critical element going forward. And it sets the tone for all actors in a country, including the government, all national enterprises, national civil society, and everybody else, including the foreign enterprises that work there as well. But it's a critical piece. And in order to resolve that, we'll say again, the informal economy and informality is a serious impediment to implementing the rule of law. If 90% of the population works outside of the formal sector, in building the rule of law will be very, very difficult. So addressing informality is essentially a prerequisite to instituting rule of law in countries. Thank you.
Thank you. Now I give the floor to the representative of civil society.
Muchas gracias.
Thank you very much. The participants of the International Platform Against Impunity attending this meeting, we believe that the Inter-American Human Rights Commission could play a very relevant role observing from close the implementation of the guiding principles and the way they're implemented in order to make sure that they're not badly interpreted neither by enterprises nor states, and to ensure that the international standards, human rights standards, are respected, including the rights of indigenous peoples, about which the inter-American system has developed some important jurisprudence, as the representative just mentioned a moment ago. And above all, paying special attention to the impact of major enterprise projects on the lives of indigenous women. I'd like to ask whether the Inter-American Commission has assessed the possibility of playing this role of closely monitoring the implementation of the guiding principles, and whether the Inter-American Commission would actually have the resources which would be required to do so. Thank you.
Buenos días.
Good morning. My name is Francisco Yodera. I'm the presidential advisor of the government of Colombia. I'd like to share with you, Mr. Chairman, and with the members of this forum, some thoughts from the side of the Colombian government. We welcome the assistance on behalf of the government of Colombia, all of those who have made it possible to hold the first regional forum in Latin America and the Caribbean on enterprises and human rights, which Colombia had the honor of hosting at the end of last August. This was the first step for the building of a dialogue between stakeholders, which I have no doubt will facilitate the building of synergy and the identification of best practices in tangible implementation of the guiding principles in our region. Mr. Chairman, I would like to mention two initiatives by my country which relate directly to human rights. The first is a comprehensive integrated policy in the area of human rights and international humanitarian law. And as it was established, the 33 departments or provinces of the country were examined. We worked with more than 20,000 people coming from 9,000 different social organizations and local and regional governments, and accompanied by the international community. And we hope that this comprehensive policy, integrated policy, will be initiated at the beginning of next year. Next is the building and implementation of a national human rights system and international humanitarian law, which is a tool by the government, which has been acknowledged, recognized by the High Commissioner for Human Rights, Ms. Navi Pillay, and in general has been by the international community. This is the main approach for the coordination of a response by the state in the area of human rights and international humanitarian law. Within this initiative, I think it's important to mention the establishment of public policy lines which incorporate and actually implement in an effective way the guiding principles on human rights and enterprises through a multi-stakeholder, transparent, and cordial dialogue between member states, civil society, and enterprises. We hope that with these lines on human rights, we will be able to guarantee public and private investment, which are absolutely essential for development, and it must be sustainable in terms of the rights of all citizens. Thank you.
I give now the floor to the representative of civil society.
Muchas gracias. Mi nombre.
Thank you very much. My name is Katia Salazar, and I represent an organization known as Foundation for Due Process, an organization which is working regionally in the area of human rights and the state of rule of law based in Washington. I just wanted to stress from the presentation that we heard from the representative of the Inter-American Human Rights Commission a very important step that was taken recently, which the Commission actually took recently, in terms of having a thematic hearing where for the first time there was a reference to the responsibility that might indeed have the host states where the human rights violations actually occur, but also the possible responsibility that states might have, which are those where the enterprises are based and which are related to those facts. This step, I think, is an extremely important one, and I'd like to say that it is not only a theoretical exercise or an academic proposals of those who requested the hearing. Rather, it is in fact an extremely pragmatic, hands-on situation. If you look at the realities of Latin America, I don't know the situation in Africa or in Asia, but specifically in the case of Latin America, if you look at the numbers, the statistics, you will see that about 70% of the mining investment actually comes from Canada. So if we have this figure, which is so high, and there is no response from the side of the states, the hosting states, and if we see the very favorable conditions for foreign investment in those strong countries, I think it is high time for us to think carefully about the role and responsibility which those states where the multinational enterprises are based and which come and work and carry out these projects in our region. Thank you.
I thank you. And thank you also for your management of time. I give the floor to the representative of the state.
Thank you, Mr. Chair. I speak on behalf of the European Union, and I wish to thank the working group for the organization of this forum today and the Office of the High Commissioner for Human Rights for its support. We would also like to thank the core group, Argentina, Ghana, India, Norway, and the Russian Federation for their ongoing efforts in this field. The European Union would like today to share our experience on what we have been doing in this area. We are dedicated to a two-pronged approach. First, to ensure that the guiding principles are fully understood and adhered to at European Union level, and second, to promote their implementation through its external action. At EU level, the EU and its member states have taken tangible steps towards the adoption of national plans on the guiding principles. The United Kingdom was first to launch an action plan on business and human rights, and a large number of EU member states intend to have an action plan in due course and are working on it. As part of the duty to protect, the European Commission has developed guidance material to enterprises on meeting the corporate responsibility to protect. This includes a guiding material for 3 industry sectors, as well as a guide for small and medium-sized enterprises. As concerns the EU external activities, our objective is to promote a global level playing field on business and human rights. This is why our guiding material is of global applicability and of relevance to companies operating inside and outside the European Union. Furthermore, we have included in recent free trade agreements references to the promotion of corporate social responsibility. A further important element is that the European institutions ensure policy coherence of our own policies, which are of relevance to business and human rights. This includes in particular specific human rights and labour issues, such as child labour, forced labour, human trafficking, gender equality, non-discrimination, freedom of association, the right of collective bargaining. Mr. Chair, a lot has been done so far. This is our judgment, but still we think that we are at the beginning of the implementation of the guiding principles. In the end, our success would be measured against the capacity to prevent human rights violations and to ensure effective access to remedy. Thank you very much.
Thank you, sir. I see none. Now I give the floor to the representative of civil society. You have the floor, sir.
Muchas gracias, señor.
Thank you very much, Chairman. Pedro Rafael Maldonado is my name, from the Legal Action Center in Guatemala called CALAS, and we're also a member of the Convergence for Human Rights in Guatemala. We're all based in Guatemala City. I'm here to come to tell this honorable forum about the very severe crisis and risk that our male and female lawyers suffer. We are opposing the development of extractive industry projects, and we are suffering because of a highly structured strategy implemented by Canadian companies in our country. They essentially developing a criminalization process for all those lawyers that are supporting the communities, helping them to protect and safeguard their fundamental rights. Now, to be very specific, Chairman, I'm asking the working group, and seizing the opportunity of the presence of the Inter-American Commission in this forum, to urge the Special Rapporteur on the independence of judges and lawyers to carry out a visit to the Republic of Guatemala so that an investigation can be conducted looking at the risks that the lawyers are suffering as a result of the activities of the Canadian mining companies. This is the Minera San Rafael activities in the San Rafael region. They have actually gone as far as attacking defenders of those communities. Thank you.
Thanks for your important statement. According to the information I got from Secretariat, the time for intervention is over right now. I would like to invite the speaker, the panelists, to respond concisely on the important and valuable point that has been raised during the intervention. You have the floor, sir.
Merci, Monsieur le Président.
Thank you, Chair. I'd like to thank all of the speakers for their questions and comments. In fact, there weren't really that many questions addressed to the Council of Europe, but I would like to react quickly to some of the comments that were made. I'd like to, first of all, thank the French Ambassador for Human Rights. The examples she gave concerning her country are very interesting. The
plan of action is going to be adopted in the near future by France, and I have great hopes that the French delegation will be very active in the working group in the Council of Europe, which is looking specifically at all of these issues. And I would make the same remark to the representative of the European Union, who is working in very close cooperation, of course, with the Council of Europe. And I hope that all of the initiatives that are taken by the European Union will also feed into the deliberations of the working group in the Council of Europe. Now, on a matter of substance, as a representative of the business sector who started their statement by saying that it's obvious that there is a difference between the role of the state and the role of a company in the responsibility to protect. Well, I think we all agree with that fact. But let's not forget, however, and I was very interested to hear my fellow panelists speak of positive obligations that states have. As the European Human Rights Court has said, the rights and freedoms guaranteed in the European Human Rights Convention should not just be theoretical or an illusion. States need to take effective measures to realize those rights in practice. And here, I think, without trying to blur the responsibility of states with the responsibility of business, I think that at least there is a point of convergence between the two. Thank you, sir.
I give the floor to the other panelists.
Thank you, Chairman. I just want to comment on a few things. One, on the issue of the state duty to protect. And I want to state that in the African Commission, state report every 2 years. And this is an opportunity we can use to further the implementation of the guidelines through state reporting. The other issue I take a note of, the issue of thematic hearings from the Inter-American Commission that was mentioned by CSO. And according to our charter and rules, we can take inspiration from other organizations, and we've been doing so, especially from the Inter-American. This is something we can also explore. On the issue of getting the principles understood, I think it's a major issue that, again, we can propagate through our promotional missions to the respective countries which each commissioner is assigned. On the attack on human rights defenders, again, this is another issue we can take up with the state parties when we go to visit them. I think this is an important thing. And also, now that many African countries are making their national action plan, I think this is an area where, as an African Commission, we can come in. And lastly, I think we shall also be borrowing from those countries that have already started implementing to see how they guide their countries, and we can take a lesson from that. I thank you very much.
Chair, I will be very short. I would like actually to respond on the European Union attempts, which I also welcome in terms of creating guiding materials for certain industries and for small, medium enterprises. We might also be able to learn from that process. But you also include there on the free trade agreement. There is some questions underlined that bothers me a lot in this context. As a matter of fact, we are living in an unequal world, in a unbalanced relationship between the advanced countries and the developing or the major emerging economies. That there are some discussion that this is going to be the criteria of business of human rights could be used as a non-tariff barriers to pressures actually products from developing and emerging economies. I think it has to be clarified that that is not the purpose of adhering and building states' responsibility, state duty to protect, at the same time in the process to encourage business conduct to be in compliance with what regulatory framework has been established. So this is actually the dilemma. On one side, our region, for example, is very much welcoming foreign direct investment, but when foreign direct investment is also then bluntly using criteria, there will be no investment if there is a certain human rights violations taking place. It is not going to be as simple as that. It has to be measured with a clear criteria what kind of human rights you're talking about, because human rights violations is also taking place even in the developed countries, particularly in the growing xenophobia in the Western countries. So these are the considerations that I think should be addressed by all states, party, the business, as well as civil society. Thank you.
Thank you, sir, for your intervention. So I give the floor to Madam María.
Uno que se refiere a la situación de afectación.
Well, there was one comment referring to the situation of indigenous women and the Commission's ability to tackle that issue and provide follow-up on it. The unit on the rights of indigenous peoples carried out a visit to Guatemala from the 21st to the 30th of August of this year, 2013. And while there, they were able to carry out a number of observations at first hand. They didn't just visit the capital city. They were able to visit various local municipalities and areas where whole indigenous communities have been resettled as a result of company activities, companies that are mining natural resources. The rapporteur on indigenous peoples is currently carrying out consultations and collating information with a view to putting together a regional report on the situation of indigenous people in the Americas, looking at the multiple forms of discrimination and violence which affect indigenous women and which act as a barrier to the exercise of their rights. Now, this is in relation not just to states and state agents, but also in relation to the actions of companies and indirectly security company staff that have attacked them. We have even received reports of cases of sexual violence. At the moment, the Inter-American Commission is drafting a specialized report on this subject. And we are considering cases that are still in the substantive analysis phase, looking at environmental impact, the right to health, the right to life, and the personal integrity of indigenous peoples. So in order to solve these cases and establish some case law, the Inter-American Commission will be able to use the interpretation clause in Article 29B and will also consider the guiding principles of the United Nations. Thank you.
Now, I would like to conclude that we do have a very productive meeting this morning. We have open and also a very honest discussion. Allow me to thank all of the speakers, the panelists, and also all of the people from the floor who make intervention. So there will be no break for the next panel. So I would like to say that the meeting suspended for half minute.